Right. Thank you. Hi, and welcome everyone to this third event in our series of webinars on technology and criminal justice. My name is Bruno. I'm the legal director of Fair Trials based in our London office. I just want to first of all remind everyone that today's session is being recorded. But if you're shy, you don't need to do or say anything. You won't appear in the recording unless you decide to participate actively. Our webinar today focuses on criminal justice by algorithm, and we'll be looking into how algorithmic tools are impacting pretrial detention, sentencing, and probation decisions. As usual, we have a distinguished panel of expert speakers whom I'll introduce in a little while. And after we hear from our three speakers, we'll open up for questions, finishing at 5:30 UK, that's 6:30 in Brussels, or if you're joining us from New York or Washington, that would be 12:30. Please feel free to ask questions in the Q&A function at any point, and we'll do our best to get through all of them. If you'd like to appear on screen to ask any questions directly, please write your question on the Q&A message board and indicate that you'd like to do so. We may also do quick polls on issues that arise during the discussions, so please do look out for them as well. So let's get started. Okay, so criminal justice decisions are increasingly being influenced or even made by machine learning algorithms and automated decision-making systems. These are sometimes referred to as artificial intelligence or AI systems. In our previous webinar, we discussed predictive and risk assessment systems in policing, which have been receiving increased attention in Europe and elsewhere. But similar systems are now also being used in pretrial detention, sentencing, and probation decisions. These are incredibly sensitive and important decisions that have serious consequences for individuals, but they are being outsourced nowadays in certain cases to predictive and risk modeling systems. These systems can influence whether people are held in detention, awaiting trial, or released. They can make the difference between a custodial sentence and conditional release, and they can also determine when a prisoner can be released from their sentence on parole. These automated systems can have serious implications on human rights, the right to a fair trial and the right to liberty, of course, privacy and data protection rights as well. And much like predictive policing tools that we discussed last time, there are serious concerns about discrimination based on race, socioeconomic status or class, nationality, and background. Just to give you a little bit of background to risk assessment tools, these risk assessment tools are basically mathematical recipes to group people into risk categories. Many tools developed for use at the pretrial stage are then repurposed for use at later stages of the criminal justice process and vice versa. Algorithmic risk assessment tools forecast outcomes based on historical data. The objective is to find patterns in past data that correlate with some definition of success. In the pretrial risk assessment context, tools typically define success as when an arrested individual doesn't fail to turn up to court and or is not rearrested during the pretrial period. The tools then assign a range of scores to individuals based on their risk profile. Those scores are then grouped into risk bins, ordered from low to high. The designation of risk is somewhat arbitrary. What qualifies you as low or high depends on the threshold set by the developers and merely denotes the risk a group represents relative to other risk bins. Though often touted as capable of predicting an individual's level of risk, the tools are actually incapable of making individualized predictions. They instead study data from many individuals and then forecast aggregate group risk. A risk score therefore indicates that a person shares traits with a group who succeeded or failed at certain rates, but in fact, the score provides no information about how a specific individual will behave if released. Risk assessment tools assess several types of risk. Some tools predict the risk of failing to appear, risk of arrest, and risk of arrest for violent crimes separately. But many do not, and instead they combine these probabilities into one composite risk score, representing risk of either a failure to appear or any arrest. Many tools also don't distinguish between arrest for a crime of violence and any kind of arrest. Regardless of whether these tools combine or aggregate crime predictions, they almost uniformly provide the probability of a new arrest rather than the probability that the individual will actually engage in criminal activity. So it's a host of factors influence whether police detect offences and make arrests. It's perhaps more accurate to describe the tools as predicting the behaviour of law enforcement rather than the real level of risk. I think for the time being, that's enough for me because I'm conscious of the fact that nobody tuned in to listen to me talk, and also because we've got some amazing speakers lined up for you. The first of our speakers is Colin Doyle. Colin is a fellow and lecturer from Harvard Law School. His research examines how technological changes to criminal legal processes affect both the application and meaning of the state and federal constitutional law. He has a particular focus on decisions at the margins of criminal law, including bail setting and fees and fine determinations. His research often explores how overlooked features of new technological processes can inform and challenge long-standing beliefs and practices within constitutional law, criminal law, and criminal procedure. So Colin, you have the floor, and I look forward to hearing some more about these kind of pre-trial risk assessment tools in the US, because this is where a lot of these systems are being developed.
Thank you so much, Bruno, and thanks to Fair Trials for inviting me to speak. I should just say, to start, we may have some intruders in my presentation today. In fact, we have one right here, right now. My family has been exposed to coronavirus, so we are quarantining right now, and I have a toddler and a baby here, so I appreciate everyone's patience. I'm just gonna share my screen right now if I can. Does that work for everybody? Great. So as Bruno said, my name is Colin Doyle. I'm a lecturer on law and a Clemenko Fellow at Harvard Law School. My research focuses on bail reform and pretrial incarceration in the United States more broadly. I'm part of a research group with data scientists, anthropologists, and computer scientists at MIT and Harvard. We focus on algorithmic fairness and technology and criminal law more broadly. When it comes to pretrial risk assessments, we've taken a long look at them. We've popped open the hood on these tools. We've followed their implementation across the country. And I'd like to present today some of our broad thoughts and conclusions. I'd like to state up front that our main conclusion is that actuarial pretrial risk assessments suffer from serious technical flaws. They can't accomplish what they're supposed to do, which is to identify people who will commit crimes while on pretrial release. They can't even come close to accomplishing this. When these tools make mistakes, the harms that result are not evenly distributed across society. Instead, the harms fall primarily on poor communities and communities of color, particularly Black communities. These particular problems are unavoidable with pretrial risk assessment tools. You cannot design around them, and you cannot fix these problems. In light of these deficiencies, it's important, I think, that we ensure that risk assessments are not a distraction from other reforms that hold more promise. And I would argue that these deficiencies reveal serious moral problems with how we approach pretrial decision-making in the United States more broadly. So my presentation proceeds as follows. Take a brief look at how pretrial risk assessments are made. I'll talk about the drawbacks to these tools, and then I'll touch briefly on the the role of prediction in pretrial decision-making. To start with how pretrial risk assessments are made. With any machine learning tool, what you're going to start with is an outcome of interest, the thing that you're trying to predict. Actuarial pretrial risk assessments tend to look at 3 outcomes of interest, as Bruno said earlier. It's missing a court date, being arrested for any reason, and being arrested for a violent crime. The first step, if you're building these tools, is to collect historical data. Pretrial risk assessments look to observable patterns in data and then predict that the future will follow these same patterns. So here, on this slide, I just have an example of one piece of data that every pretrial risk assessment tool on the market uses, and that's measuring the correlation between age and arrest. So if we look at the x-axis here, we've got age. If we look at the y-axis, we've got probability on one side, frequency on the other. With these bar charts at the top and the bottom arm, this is like an actual data set coming out of Florida. We're looking at the top, those bar chart pieces, those represent people who were arrested on pretrial release, and the bar chart part at the bottom is representing people who were not arrested on pretrial release. What we see here is that there's a general correlation. As age increases, arrest decreases. That's what's captured by that red line here. So if you were to build a risk assessment just looking at age, based on your age, you would get a lower risk score if you were older, and you would get a higher risk score if you were younger. We can't know with certainty in any case. You can see at every age there are people both at the top and the bottom, but it's a general trend line. Of course, modern risk assessments use more than just age, although age is the most predictive factor within these tools. But using algebra, the creators of these tools just draw lines with math through a lot of these different features and then combine them together into one prediction. So what are the problems with these tools? Broadly speaking, I'd say that there are 3 problems: that they're racially biased, they're not accurate, and they're secret and unaccountable. As far as problems go, racial bias has gotten the most attention in the United States. A few years ago, a ProPublica investigation found that the Compass pretrial risk assessment tool had different error rates for Black people than white people. The tool incorrectly predicted that Black people were higher risk much more frequently than it incorrectly predicted white people as being high risk. And it incorrectly predicted white people as being low risk much more frequently than it incorrectly predicted Black people as being low risk. This ProPublica investigation launched a whole host of reports, news articles, and academic research into bias and risk assessment algorithms. I don't have time to go into all the details of all of these reports here, but I think that we can pretty much draw 2 main takeaways from this research. The first point is that there's no easy technical fix. There's no easy way just with math to resolve these racial problems, these problems with racial bias, and that there are competing understandings of fairness that can't each be optimized. The second one goes back to an old computer science adage: garbage in, garbage out. The problem here is that as Bruno alluded to earlier, the training data that we have was not collected to build these models. We're relying on policing data, we're relying on court data, and these are more a measurement of law enforcement activity and how people are treated in a court system than they are a measurement of underlying population activity. Not only that, but decades of empirical research shows that at literally every single stage in the criminal legal process, Black people are more likely to be punished and face harsher punishments than similarly situated white people. This data drives these models and reinforces and reentrenches these racialized distortions. Another problem is that these tools are not that accurate. The problem here is that predicting violence is hard, and the burden of proof for incarcerating people pre-trial is and should be high. Jurisdictions are adopting these tools because they're looking for a tool that can tell them who they ought to jail pre-trial and who should be released. But actuarial tools can't deliver on that. They're not good at finding people who will commit violence on pre-trial release. So right here on this slide, I have a flag that we see with a popular risk assessment instrument, the public safety assessment. If you were a judge at a bond hearing that in the jurisdiction in the United States that uses this tool, every person who is accused of a crime and shows up in your court will be flagged or not flagged for new violent criminal activity. As a judge, you don't have background information exactly on what this flag means. you just know that, some around 10% of the people who you see in court have this check mark next to their name. Most likely, if there's a prosecutor at this hearing, they're arguing for the detention of someone who has this flag. So what does it mean? Well, if we look at the training data that was used to build this tool, what we find is that this flag correctly predicts violence 7% of the time for 7% of defendants. In other words, around 93% of the people who are flagged for violence will not go on to commit a violent crime if released. Not only that, but the overwhelming majority of people who will go on to commit a violent crime will not be flagged. I just want to pause on this slide for a second. I know that we have an audience with people from many jurisdictions with different rules of evidence and burdens of proof. But in no jurisdiction does the law allow for people to be incarcerated for this reason. It's important to note, Bruno talked about this earlier, this doesn't mean that an individual person here actually has a 7% chance of committing a crime of violence if released. If we want later, we can talk about problems with thinking about individual risk in this context. What this number means to me is that for every 100 people you incarcerate following this tool, you could prevent roughly 7 of them from committing a violent crime. The cost of preventing those 7 people from committing a violent crime through incarceration is the incarceration of 93 people who would not commit a violent crime on release. Lastly, another problem with these tools, and this one is something that could be fixed, but hasn't been approached as much in the United States, is that they're secret and unaccountable. These tools do not share the data that's been used to build them. Their models are not available to be studied and interrogated by experts, let alone people who are subject to them within the criminal legal process. I think Pilar is going to talk a little bit more about work that community groups have tried to do to challenge these tools and to make them more accountable. But briefly, they can distort judges' decision-making because judges don't know really what's going on in the tools. Judges have a choice. They can either accept the recommendation that comes from the tool or substitute their own judgment. But the tools aren't really providing information that a judge can use to supplement a judge's decision. And they can't be evaluated by experts, and they're unaccountable to the broader community. I think one thing that's important to recognize is that judges themselves are not better at prediction than these tools. Part of the problem here is prediction itself and our reliance on prediction within the pretrial process. There's a Danish proverb that I think of often. It's difficult to make predictions, especially about the future. For both judges and algorithms, predicting the future is risky business. We don't know what the future will hold. We allow for excessive incarceration when we expect judges and we expect algorithms to know in advance who will commit serious crimes or not. No one can know that. Problem with the United States and our pretrial decision-making process is that we have assumed that prediction itself can be a limiting principle for pretrial incarceration. The truth is, though, that prediction itself must be carefully limited within our pretrial processes. All right, that's it for me. For now, I'm eager to hear what other people, what our other panelists have to say, and to answer questions later on. I'll just say briefly, my email is up. I sit here at my desk all the time thinking about these issues. So I welcome anyone who has any questions outside of this presentation. Please don't hesitate to reach out.
Thank you very much, Colin. That was a really useful insight into risk assessment tools in the US. Obviously, the pretrial risk assessment tools have been extremely controversial in the US. And I suppose one of the reasons why we're having this conversation today is to figure out kind of what kind of lessons can be learned from the experience of the US, especially in case we see something like a transatlantic creep, these systems being developed in the US, but somehow being used in European jurisdictions, which I understand is happening to a limited degree. And that brings me nicely to our next speaker. So next up we have Griff. And as a lot of you joining this webinar might already know, Griff is a legal and policy officer at Fair Trials, based in the London office, and he is our resident expert on the use of artificial intelligence in criminal justice, particularly in Europe. And this is not a topic that's in any way new to him. He has previously investigated and researched the use of algorithmic and automated decision-making systems in pretrial detention, sentencing, and probation in the UK. So, Griff, like I was saying earlier, this is something that has been talked about quite a lot in the US, but would it be right to say that there is something like a transatlantic creep in the sense that more countries in Europe perhaps are beginning to think about employing these systems in their own criminal justice systems?
Thanks, Bruno. Yeah, absolutely. And I just want to reiterate what Colin said around the kind of the fundamental issues with the theory behind these models, which underpins these systems, is that the predictive algorithmic systems, whether we're talking about in policing or whether we're talking at the pretrial detention, sentencing, or probation stages, they are ultimately statistical models which are built, created, and operated using criminal justice data. And that data, that information, those criminal records will be representative of the structural biases and inequalities in the societies which that data represents. And that data, being criminal justice data, is also comprehensively lacking in the kind of detail that's necessary to make truly accurate predictions or decisions about individuals. Structural racism and other forms of discrimination are a fundamental reality in policing, in criminal justice. That's no different in Europe than it is in the US. In Europe, Black people, people of color, and Roma are overrepresented in criminal justice systems and police records as a result of over-policing and increased attention due to that structural and societal discrimination. And so that data is then used to build these systems. And I'm going to give some examples of how those systems are being used in Europe and specifically the UK systems which I've previously investigated. So the first one I'm going to talk about is one being used by Durham Police, which is a police force in the north of England. And it's called the Harm Assessment Risk Tool, or HART for short. Now, Durham Police developed this tool themselves, and the aim of this tool is to profile suspects to predict their risk of reoffending in the future, giving them, similar to the systems that Colin's spoken about, giving them a risk score of high, moderate, or low. That's their risk of reoffending in future. This is a machine learning tool, sometimes also described as artificial intelligence, and this tool, this score that it gives out, is then used to advise whether to charge a suspect or to release them onto a rehabilitation program. If individuals who've been assessed by the HART system are assessed as moderate risks, if they successfully complete that rehabilitation program, they will not receive a criminal conviction. So this system, and being ranked, basically not being ranked as high risk, therefore has significant consequences for individuals' criminal justice outcomes. And the principle of using historic data about an individual to make predictions about their potential future behavior, it brings into question the presumption of innocence, the right to a fair trial, also issues around the right to privacy and data protection. So this HART algorithm, it was built on a data set using historic criminal justice data going back 5 years. It used 35 different pieces of information to make that prediction. 29 of those were criminal justice information about an individual's criminal justice history, whether they had a record or not, for example. There were also police intelligence reports, so that's not necessarily objective evidence, but potential hearsay, intelligence, police evidence. Other variables also included age, gender, and 2 types of residential postcode. Now, there are clear issues with the criminal justice data being used in those systems, as has been mentioned, but there are also very serious problems with the non-criminal justice data. And I'm going to talk about how that, like the clear discrimination found in that criminal justice data, is inherent in basically all forms of data and will find its way into these systems when they're designed. So an investigation into this system found that one of those postcode variables, that non-criminal justice information, was a commercial marketing data product from a data broker called Experian. And that piece of information was ultimately postcode stereotypes. And these were postcode stereotypes which were created from millions of pieces of information, which included census data, ethnicity, health data, employment, exam results, child benefits and income support, and family and personal names linked to ethnicity, as well as other information scraped from websites. That information was used to profile basically all adults in the UK into different stereotypes based on their postcodes. You know, based on what postcode you're in, you were more or less likely to be considered to be a member of this stereotype. Now, these stereotypes were incredibly offensive and racist, and they included categories such as Asian heritage, disconnected youth, crowded kaleidoscope, families with needs, or low-income workers. And for each of these stereotypes, which were fed into this Durham prediction tool, there were kind of demographic characteristics associated with that based on this information. So, for example, Asian heritage, and I'm quoting from the information that was discovered. Asian heritage individuals under these stereotypes were characterized as being part of extended families living in inexpensive, close-packed Victorian terraces, and that when people do have jobs, they are generally in low-paid routine occupations in transport or food services. Similarly, another stereotype called crowded kaleidoscope were described as multicultural families likely to live in cramped, overcrowded flats with names like Abdi and Asha. Another one, families with needs, were profiled as receiving a range of benefits with names like Stacy, while low-income workers were typified as having few qualifications and were heavy TV viewers with names like Terence and Denise. Now, Durham Police paid this data broker for these profiles. This is a commercial product available for use not just by the police, but other people wanting to build these types of systems. But Durham Police paid over £45,000 for this information, specifically targeting the Durham area for use in its heart forecasting model, which was then used to influence criminal justice outcomes. Like, it probably doesn't need to be said, but it's obviously appalling that such discriminatory profiling and data profiles were used for the fact that they were created in the first place, but that then they were then used by the police to predict people's risk, affecting their whether they would be held in pretrial detention or released onto a rehabilitation program. Allowing that kind of profiling data, which included not just ethnicity, but a whole host of other race and socioeconomic proxy information, including postcodes, to be used in algorithms in the criminal justice system, or indeed anywhere in the public sector or private sector really, is clearly discriminatory and will lead to unjust and inaccurate decisions. For example, people from poor areas where they can draw a correlation between higher rates of crime, whilst there is no causal link, these are the kinds of correlations that are often drawn by these systems. It risks and evidently will reinforce existing policing biases and social inequalities, and it also institutes a kind of postcode lottery of justice. One of the particularly worrying things, one of the academics, because the system was built by academics in conjunction with the police, one of the academics instrumental to the development of this system argued in favor of the inclusion of this data, saying that, you know, it was one of the strongest predictive variables and therefore had a valid place. But it's, you know, it's clear that that kind of statistical stereotyping will lead to unjust and prejudicial treatment that is the very definition of discrimination. Following the investigation of that heart system, Durham Constabulary removed that Experian, that commercial data from the system a month later. And it's also been found that since then, the commercial data broker Experian has also rebranded some of those crude and racist household profiles. For example, they've changed Asian heritage to large family living, and they've changed crowded kaleidoscope to city diversity. But these are cosmetic changes, and there's nothing to suggest that the wide range of intrusive underlying data used to create those profiles, including ethnicity data, has changed. While the removal of those overtly offensive stereotype names is positive, there are clearly deep concerns around the existence of this profiling data and the role it plays in various, within the criminal justice system when it's used. To go for another example of a system that's used at the sentencing and probation stage in the UK is a system called the Offender Assessment System, or OASIS. This is another automated risk assessment tool which is developed by the Prison and Probation Services in the UK, and it aims to assess the risk of harm that offenders pose to others and how likely they are to reoffend. There are a number of different kind of predictions that come out of this system overall. These risk assessments they influence sentencing. For example, if there's a choice, if a judge has a choice between a suspended sentence, a community order, or a custodial sentence, they'll send off for one of these wider reports, and they'll get a risk assessment back, part of which has been automatically generated, and which is obviously influential in that outcome. They also influence probation decisions, including, influencing whether people are actually released from prison. So it's very clear that this system has a tangible effect on criminal justice outcomes. The system it collates information on the offenders' previous offences, their education, training and employment, information about any alcohol or drug misuse, as well as their previous relationships, lifestyle, and other factors. This is done by a human assessor and then fed into the algorithm. And that comes out, that alongside demographic information about the individual informs predictive algorithms, and it predicts the likelihood of their reoffending, the likelihood of non-violent or violent offending. And by the end of, in 2014, so this is some years ago that this research was published, but even back in 2014, almost 7 million prison and probation assessments had been carried out under that system. So it's huge amounts of these assessments that have been going on for over the last decade. A very basic analysis back in 2014 by Prison and Probation Services found that these predictive algorithms generated different predictions based on race. They found that the predictive validity, basically whether it was accurate, was much greater for white offenders than it was for offenders who were Asian, Black, or mixed race. And the largest differences were by ethnicity, and it worked much less well at predicting the correct validity of Black offenders than for white offenders. I mean, again, it's very clear that the use of these algorithms should raise serious concern. The fact that these algorithms are using information around individuals' background, which can be proxy information for protected characteristics, and the fact that there was a clear difference between predictive validity based on ethnicity is very kind of clear cause for concern. I mean, those just two examples of the systems that are being used in the UK currently. I mean, these predictive tools, they intend to pursue legitimate objectives of preventing or reducing harm, but they ultimately are doing so in a way that targets individuals and profiles them as criminals before they've actually carried out the criminal action, the reoffending, for example, or the violence for which they are being profiled. It's particularly problematic and in some instances discriminatory that these predictive and risk modeling systems don't just designate individuals' risk levels on the basis of past actions or behavior that can be regarded as suspicious in any way, but also on account of factors far beyond their control, such as the actions of others. You know, some systems use information about whether an individual, for example, has been a victim of crime, or whether they are family members or known associates or friends of other people who have criminal records, as well as also serious issues around the use of proxy information that can be a proxy for ethnicity or socioeconomic class. As current law stands, these predictor and risk assessment systems are used in criminal justice without kind of proper legal protections and safeguards, as the current legal safeguards that we have are based around very formal concepts of suspect, charge, reasonable suspicion, which means that there aren't the kind of protections we need for these systems that are operating outside of that grey area And often they're operating completely under the radar, with many people, just not aware that these systems are being used. So there's definitely a need to revisit the way that criminal justice safeguards exist and operate in the context of these systems. And I think it's arguable that these types of very high impact, fact sensitive criminal justice decisions should never be delegated to automated processes, particularly those that operate by identifying correlations between individuals' background and their behavior, rather than actual causal links. There are very few safeguards against these types of systems at the moment. So I think that's everything from me. I look forward to any questions about this later.
Thanks very much, Griff. That's a really helpful insight into how these systems are being used in the UK. And I think, one of the really interesting things about the HART model in particular is that in these discussions, one of the primary criticisms against algorithmic decision-making tools is that they are primarily reliant on criminal justice data. And HART is an example of where, well, to a degree that's the case, but we can see the risks of relying on other types of data that are not necessarily criminal justice related, and they actually have even more dire consequences and are likely to provide irrelevant results. Just before we move on to the next speaker, Griff, I was just wondering, obviously the HART has been around for a while. Oasis, I think, has been around for a while as well now in the UK. And what can you say about the current trends in the UK in terms of deploying these systems? Is there any resistance to it, or is it something that is gaining momentum in the UK?
Yeah, it's definitely something that's gaining momentum. I think driven by kind of a decade of austerity and cuts to public services, including policing and the criminal justice system, mean that people operating those systems, whether in police or in the Ministry of Justice or other criminal justice authorities, they're incentivized to cut corners, to develop basically systems which provide the solution to all of their problems. And these systems are often seen as a way of reducing cost and coming out with kind of neutral, factual, neutral, objectively fact-based decisions. And it's happening widely in policing, and it's also happening obviously in the pretrial detention stage. And something as well that happens is a kind of a function creep. These systems are developed either in policing or in another end of the criminal justice system, and then they're applied along different stages of the criminal justice system. For example, tools used in pretrial detention are often also then used at the sentencing and probation stage, where there are obviously very, very different fundamental reasons for going with the way that criminal justice system work in terms of sentencing and probation, to then use a system that's been designed for example, for pretrial detention, either to potentially reduce pretrial detention, to then use that for sentencing and probation is going to throw up a whole load of different questions and problems. So these systems are kind of function creeping all over, certainly in the UK, and in other European countries, and they're often doing so completely under the radar.
Thanks very much, Griff. Just before I move on, we have been receiving a few interesting questions, but if you have any other questions to ask the panelists, then please send them our way. Great. Moving on now to Pilar Weiss. Pilar is the founder and director of the Community Justice Exchange. It is a US national hub for developing, sharing, and experimenting with tactical interventions, strategic organizing practices, and innovative organizing tools to end mass incarceration. They provide support to community-based organizations that are building a new vision of community justice through bottom-up interventions in the criminal, legal, and immigration detention systems. In 2016, Pilar launched the National Bail Fund Network, a collaborative partnership for the 50+ community bail funds working across the country to end detention in both the criminal, legal, and immigration detention systems. Immigration system, sorry. Pilar has worked as an organization and strategist across the social justice movement for over 20 years. So Pilar, so we heard from Colin earlier on that there have been many controversies around the use of these risk assessment tools in the US, and there's a lot of pushback. And it'd be interesting to hear from you kind of what the outcome of those criticisms have been in the US so far, and what's happened since in particular since the grand exposure around tools like Compass.
Absolutely. Great to be here. Thanks, Fair Trials, for pulling this together and for having us present today. I'm going to talk a little bit about how organizers and community-based organizations particularly are confronting pretrial risk assessment tools and risk assessment across the criminal legal system in the US, and some of the challenges, and just really build off of some of the information that Colin and Griff have both given. I wanted to just start with like a little context that I think came up in some of the questions and react a little bit to something that Griff had brought up with the harm system, which is that, you know, we often talk about, when we think about risk assessment tools, right, it's often the commercial products that we think about, like the Compasses or the Arnold PSA, right, that are developed by a vendor and then sold widely, right? And I think that we have seen in the US that we've got this real mix of, there's a dominance by those commercial providers, particularly like the PSA, which is the dominant pretrial risk assessment tool in the US because it's being pushed by a foundation that's giving people, you know, jurisdictions free access, others to be bought. But there are many, many, similar to the Durham example that Griff has given, right, that are sort of bespoke or local, right? We have many states and counties that are making their own risk assessment tools, either because they hire data scientists, they buy it from a vendor, or they have somebody, or they have a judge who decides that they've created a risk assessment tool, right? And so I think we just, to like make sure we have that context that in the US right now, and I think this is probably one of these exportable issues, we have about 150 types of pretrial risk assessment tools that we're confronting across the country, right? And the majority of people in the US now live in a jurisdiction that is using a pretrial risk assessment tool of some sort, whether it's one of these commercial products or it's something that a local, you know, was constructed locally. And so that's sort of that's the landscape we're in. So the focus that I wanted to just talk about for a few minutes is, you know, I think one of the things that organizers and the communities that are the most impacted by the use of these tools are having to confront is just really the charade of the science that, you know, and Colin has addressed this quite explicitly. Teammakers have discussed and even sold the use of pretrial rats. We call them rats often, right? Risk assessment tool. The way that they have sold this, you know, within policy discourse, within, you know, to the voters, if it's something that's been passed by referendum in the US, is that this is this fair system, right? And there's a lot of attention, and a lot of the press and a lot of the inquiries have really focused on the actual scoring, right? So we talk a lot about like what factors are used, and it's as Griff and Colin have talked about, you know, it's this mix of things from the criminal legal system, as well as, you know, openly racist and classist data points that are being used as quote unquote science. I think the big piece that we have been focusing on as organizers is what happens in the implementation side of things, right? So what happens with judicial interpretation of the scoring, and the fact that all of the decision making around use of the scoring is deeply political, right? There's not some flat, beautiful list of bins and scores, and that's how it's implemented. It's a highly political process of how these scores are turned into detention and supervision decisions against human beings. So I wanted to give a couple of examples and sort of dig into that a bit. First, I'm just going to, there's sort of three areas that we see like really big gaps in, or just really big differences in sort of what has been sold and what has been discussed, and then what happens in reality to human beings stuck in, you know, in the criminal legal system. One is that, these scores are turned into decisions, right, or into recommendations is often how it's phrased, right? And so for many pretrial risk assessment tools, the second part of the tool after the scoring, right, Colin went through sort of the main categories of data that are used for the scoring. There's what's called a decision-making framework that turns the, what does medium risk mean? What happens to somebody? What is the recommendation for somebody who's on this scoring of low, this scoring of high? Decision-making frameworks often are like a grid, right? And they sort of say, in this area, on these scores, the person should be released. On these scores, the person should have electronic monitoring or, check in with the probation officer. In this category, they should be detained. There's no set decision-making framework, right? We see the same tool, for instance, the Arnold PSA, one of the most widely tools in the USA. If you look at multiple jurisdictions using the exact same tool, their decision-making framework is different. They can move the needle depending on, do they want to release more people? Do they want to detain more people? Are they under some sort of federal investigation on their jail, so they're trying to reduce more people? Did they suddenly build a new jail and they actually want to have more people in that jail, right? And so we often in policy debates focus a lot on the scoring, and we've really been moving more into the decision-making framework is where there's a lot, it's very, very flexible and very, very political and very, very localized, right, within the same tool. And another area is exclusion lists, right? We often don't talk about this when we're talking about scoring, that many jurisdictions will then create an exclusion list of charges or, a particular mixture of charges and scoring that they're going to exclude from using the risk assessment tool. And then they'll just detain people with those charges, right? So again, these are sort of pieces of the implementation that get lost in the discussion, particularly when people are parroting that these are like very scientific and are exactly following these scores, which, we already know from Colin's presentation that that's all, that's not real, but still, if that's where your focal point is. And finally, all of this data, all of these scorings and the decision-making sort of matrix that sets up a set of recommendations, they're purely just recommendations. And we see judicial overrides being a norm, right? And so it's often measured as adherence to the recommendation being really variable, and another place where racism and classism come to play, right? So one of the few robust studies of the use of pretrial risk assessments was done in Kentucky in the US by a academic named Meg Stevenson. Colin, maybe you can put a link to that paper in the chat. And she found that, and this has been sort of replicated in a couple other places that are using the PSA, when the risk assessment tool recommended that people be detained, there was a much higher level of adherence than when the tool recommended release. So you saw more instances where the judges would say, oh, even though the tool says release, I know from my years of being a judge that actually they should be detained or they should have heavy supervision. And so we keep seeing that play out in other jurisdictions. There's some data coming out in a number of other places in the next few months that are showing a similar trend, right? Because there's so much bias already built into the system, judicial practice, or if it's magistrates in some jurisdictions, right? They're saying, oh, I know better based on my years of being a judge. So that piece gets dropped often because there's an assumption that, well, because it was so scientific in the scoring, then it must be also in the way that it's being used. So I mentioned the Arnold PSA, right? The study in Kentucky and how we saw this really big variance in the way that judges are overriding it. Another example that I wanted to give is, there's a risk assessment tool. This is not pretrial. This is actually around release, sort of parole decisions in the federal system in the US. And they have used a system called Pattern. I'm going to read that. Pattern stands for Prisoner Assessment Tool Targeting Estimated Risks and Needs. They claim that they're actually going to also measure your needs in terms of therapeutic rehabilitation. There's a lot of been written about how absolutely atrocious some of the things that Griff was sort of pointing out in the harm, what's been used to measure. I bring up pattern though because it's under the federal system. It came out of a federal piece of legislation in the US called the First Step Act in 2018, and it set up a series of bins, right, of low or minimum, low, medium, high in terms of would people be recommended for early release from their federal prison sentences. And they created 3 big categories. And then in 2020, Attorney General Barr in the United States, the Bureau of Prisons changed those categories, right? And a study by ProPublica and some others has shown that under the new category, only 7% of Black men would actually be able to be released, while 30% of white men would be released, right? And so again, there was no science to how do you change the categories. The change in the categories of when did a 7 equal release and when did a 7 equal detain, I'm just using the number 7 as a mythical number, but when did those categories change came after there was a lot of pressure because of the COVID pandemic to release people from federal prison, right? And so suddenly the administration was saying, oh, we're going to change. So, right, these are very political decisions of we're going to change where the goalposts are based on what we don't want to happen. So, that what happened with the federal pattern risk assessment, we see again happening with the pretrial risk assessments, with other risk assessments that are used in probation or used in sentencing, right? Where again, the thresholds can be changed and manipulated locally. There's not a standard that's been produced either from a national point of view or at the state level. So moving into how are organizers confronting this, right? I work with community-based organizations across the country. I think I'm going to discuss a couple of different ways. I think a big part of this is there's been a change in the awareness, right? I think that for some time, the fight against pretrial risk assessment tools particularly was described as like a binary with our fight, with the unfortunate against money bail. So I know we're talking to an international audience. Unfortunately, in the United States, we still use money bail to detain people, right? There's 750,000 people in jails across the US who are there mostly because they can't afford the money ransom that has been put in place. So in many places, the policy conversation had been one around, are people going to get rid of money bail and replace it with risk assessment tools? And so there was a lot of focus in the organizing and some of the policy fights that we were discussing a binary choice. And I think what's happened, particularly the last 2 years, is that organizers have pushed back to realize and know from their lived experience and from what's happening in their communities, that they're actually sort of double tracking, right? In most places, we discussed, right, over 60% of people in the US live in a jurisdiction where they're being judged by a risk assessment tool. They also have money bail. There are almost no places that have gotten, New Jersey is an exception where they use a risk assessment tool, the PSA, and have mostly gotten rid of money bail. But most everywhere else, one of the conditions that is used, as part of the recommendation by the risk assessment tool is money bail, right? And so I think a lot of the organizing and pushback by communities is that we're talking about pretrial detention and having to confront it holistically, and not that risk assessment tools are being baked in and used with money bail. They're not an either or, and we have to confront it as such. But because of how baked in, right, in many jurisdictions, like the state of Virginia has been using the VPRI, which is one of a commercially available risk assessment tool for 20 years. There's many, many places across the country where risk assessments are really, really entrenched. And so running campaigns to say we're going to get rid of, these algorithmic determinations completely has not been as successful, right? It's hard to get rid of something that's already deeply entrenched. And so folks have been really going after the different pieces of it, right? And trying to minimize and sort of unwind the impact and the reliance on these tools. A couple of areas that I'll, sort of highlight is, we have a number of places, and thinking about the example that Griff gave of the harm, sorry to keep that one, that was so interesting because of the way that it was developed, right? In a lot of places where, in states and counties where there has been a locally developed tool, right, rather than one of the commercial ones like the PSA, there's been they're brewing campaigns, like we're really on the onset of this, to really take on those tools and the problems with them, right? It's been harder with tools like the PSA because they reacted to so much of the pushback to minimize down to 9 very standardized data points, right? Whereas in many states, will, places that have locally developed risk assessment, pretrial risk assessment tools will use, 80 questions, many of which are so blatantly racist, right? That you can't, like, they're outrageous, right? I was gonna read a question that's used in a new probation risk assessment tool being used in New Orleans, right? They ask a question of how much you agree or disagree with the following statements. One of the statements is, bankers, lawyers, and politicians get away with breaking the law every day. Your reaction to that question is going to determine whether or not you're being allowed to be in a diversion program. The same is whether or not how you react to the statement, you get upset when you hear about someone who has lost everything in a natural disaster, or when people tell you what to do, you become aggressive, right? So a lot of the locally developed tools, which are so blatant, right, there has been pushback. For instance, the ACLU of Colorado recently started to push on the Colorado tool. They issued a big report about how openly racist and classist and against, contrary to the American Disabilities Act, what's called the Colorado pretrial assessment tool, CPAT, is. So we have groups really taking on the locally developed tools, right, and the problems with them. We also have a lot of groups, a lot of push on really exposing and creating some transparency and accountability around the data, right? So the study that I mentioned in Kentucky has led to in a lot of states, groups starting to ask and demand, right, that there be commissions, there be oversight to actually look at the racial disparities and the use of the tools, right? After many, many years, in some places decades, of the tools just being used and people assuring us all that everything was great, this was a fair way to deal with things, there's demands that there has to actually be data collected and then hopefully be acted upon, right, to rectify. And so we're seeing a number of places in the next year or so will be the first time that many places where organizers demanded that there actually be some reporting required and some analysis at the state or county level will come up. And then a final way that I think, that's worth discussing is there's a lot of push by organizers for there to be transparency in the use, right? So going back to this question or this issue of the way the tools are used is so fluid and so problematic, right? And so in many places, there's no transparency, right? Like if I'm judged by the tool, I don't have access to that scoring, nor does my public defender, right? Or does my defense counsel. So there's been pushes in many jurisdictions that there has to be it has to be a point of record, right, in the court proceedings, that the score has to be read into court proceedings. There has to be an ability to interrogate that and to push back on it, particularly, right, when people have seen mistakes, right, where people get scored a certain way because their name was confused with somebody else in somebody else's record, right, or there's no context given. I think Colin was mentioning this, right, of I'm being scored as high risk because I didn't appear in court 10 years ago versus last year, right? Or was I actually incarcerated and that's why I had an FDA? Did I have a medical emergency? So there's been a push to really create, to demand that the tools be read into the record, people be able to actually have access to that, and to push back with the hope that that will start to open up for real, a conversation about how out of context the data is, how it's being used against people. But again, I think, Colin said this earlier, right? We can't fix the tools, right? No organizers are saying like, we're going to just smooth it out and we'll have a better version and that'll be great, right? I think there's a universal feeling that the tools have to be abolished. They have to be gotten rid of as part of our project of getting rid of pretrial detention writ large in the United States. But that right now, because of how entrenched they are and because there's such a loyalty to this concept that they're scientific and this improvement over the current system, that organizers are working on sort of exposing and dismantling pieces of it and really, really focusing on making it very clear that once, that the way that they're used is incredibly variable and adds another layer of, just complete open racism, open classism, lack of fairness, lack of standards. The final note that I'll end on is that I think the other piece that is really important that we are all working on together as community organizers around risk assessment tools is that they sort of open up this other thread that's really important in our fight against pretrial detention, which is that they've really started to normalize supervision as acceptable, right? And so most risk assessment tools, there's a very small group of people that will just be, the recommendation, if it's followed by the judge, is to just release, right? Most sort of set up a gradation of different kinds of supervision and ultimately social control, right? Whether it's checking in by phone, checking in by person, having an electronic monitor, a need to attend certain classes, a need to be in certain programs, house arrest, right? And so I think one of the big areas that we're all really collectively aware of and are concerned, and I think would be concerned and very interested in the international dialogue about how this is exported, is how these tools so quickly move the conversation away from release, and that is not, that is very rarely the recommendation or an acceptable outcome, and that supervision and surveillance along a very wide spectrum become very, very normalized as the outcomes that are acceptable, particularly within quote unquote reform conversations. So I'll stop there and really look forward to the dialogue.
Thanks very much, Pilar. Actually, the kind of note that you ended on and a lot of points that you touched on actually relate quite well to some of the very interesting questions that we've been getting in the Q&A box. And there are so many interesting questions, and I also really want to abuse my position as the moderator to kind of override them and ask my own questions, but I will try to give primacy to the questions from the participants. So I'm just kind of trying to summarize a lot of the questions that have come through. But the really interesting thing that you touched on, Pilar, just a moment ago was to highlight the fact that these conversations around the use of algorithmic systems in pretrial decision making was driven by a very legitimate purpose of replacing this very dodgy cash bail system that's so prevalent in the US, which is many people would agree is a very legitimate aim. So there's a question about, on balance, whether given the kind of the alternative that we're talking about in terms of the heavy use of cash bail, is there some sort of improvement by switching to a more risk-based assessment that these algorithmic tools are promoting? And also, there's also a more general question about, well, we are very keen to criticize, particularly as human rights activists, the use of these algorithmic systems. But are there any particular benefits that we'd like to also highlight, if there are any, in terms of using these systems? And I think I can ask you to answer that question, but I can also ask that to any of the panelists, I think, here.
I'm happy to take a little crack at it and then pass it over to Colin. I mean, I think that, right, like, this is one of the challenges, is that I think we've often been presented as a binary, right? That it's like, well, if you're going to get rid of money bail, then you have to have a different thing that will detain people. And I think our position across the country, but many of the organizers that we work with, is that, like, the presumption should be freedom, right? The presumption should be pretrial freedom. We should have a system that says pretrial freedom is the norm. And if there is going to be detention, there has to be incredibly rigorous legal proceedings in which, you know, there's a high burden of proof of why does detention have to happen, right? It has to be, like, the net should be, we often talk about, like, the most minimized net, and that only exists because of, you know, a very, and I'll leave it to the lawyers and on the panel to discuss this, right? Like, it really has robust proceedings, right, and a lot of protections, versus, right, like, the money bail system is, it's one of many things that's used to detain people, right? There's also all kinds of, we haven't gotten into, there's a whole layer of holds and different, ways that non-monetary ways that people are also held. That, in the absence of money bail, they can't get out because the system also is skewed towards the system being able to dictate detention as the norm versus pretrial freedom. So I think that, like, moving out of this idea that we have to replace and get into an idea of how do we actually, looking to all of you in other countries, right, that don't have, that, like, how do we get to a place where pretrial freedom is the norm, and then there's protections, versus where we have landed in the US, in which there's, the idea that you are, that you have pretrial, that there's a pretrial phase, really has been decimated by the way the system relies on detention. I defer more to Colin, though, if he's got additional comments on that.
Sure. I think I'll make maybe 2 points here. The first one, in terms of that Pilar brings up with false binaries. I think one of the false binaries that we've seen in bail reform in the United States is this idea that we're moving from money to risk. Money bail is about risk. That's what it has been. The reason that people are incarcerated pre-trial on unaffordable money bail is because a judge made a determination and that this person was too risky to be released, and set a money bond amount that they couldn't afford. There are some instances, this isn't to disregard, there are some instances where people are detained arbitrarily, right? Like, a judge set a bond amount without kind of any clue whether someone could afford it. We don't really know the exact ratio between how much, of the nearly 500,000 people who are detained any day on unaffordable money bond, we don't know how many of them a judge actually wanted in jail versus, accidentally sent to jail because they didn't consider whether someone could afford to pay. But anecdotally, most people think that judges are sending people to jail intentionally on unaffordable money bond amounts, and it's based on their personal determination of risk. The second point, too, if there's a role for these algorithmic tools, or if they could help in some way, I think that they're kind of brings to mind two different things for me. One thing that I think these tools have been helpful for is some of what I showed in my presentation, of just showing how difficult these kind of predictions are to make. And these tools are the most sophisticated, and they're not the most sophisticated machine learning actually, but they are like fairly sophisticated, and you can keep trying to make them more sophisticated statistical tools, and still we run into problems, and still it is empirically impossible to make determinations of who is going to commit a serious crime in the future. And they've exposed that, right? It's something of value that we have when we bring in algorithmic tools into legal processes, is they make us define our terms. They make us define what we value and define the inputs that are there. And that's different than when judges are making decisions on a hunch. Now, I'm not saying that's good and therefore we should use them, but they expose something about the system that then can invite us to, question our values and question the way that our society is approaching these problems. And that's kind of an incidental result that I think is helpful. If I'm going to find one place that I think they have proven useful, and I think is in a really interesting way, is in New Jersey. They run a preliminary risk assessment that's the same as the risk assessment that someone would have at their eventual hearing before a judge. They run that in the police station when the person is initially booked. And what this does is in New Jersey has encouraged police officers to issue citations instead of arrest. And that has had a pretty dramatic effect in New Jersey, that the number of people who spend even just a short time in jail in between the police station and their court hearing has been reduced. I don't think that you actually need something, it's beyond the scope of talking about it a little bit here. I don't think you need something as advanced as an algorithmic tool for this stage in the process, and you don't even need this particular type of algorithmic tool. But I think that I'm not a total Luddite on these things. I think that there are ways that we can use statistical tools, we can use machine learning, we can see how they've developed efficiencies in other areas of modern life. But the important thing is that we need to check our values first. And I think that that's a real problem here, is that when it comes to criminal law reform in the United States, instead of approaching it as a moral issue, we've approached it as a kind of optimization issue. And we didn't get into the bad situation that we're in the United States because we were, just doing things suboptimally. And I think that's really what has to change. But I'm not against the idea that in certain processes, some tools could be helpful.
I was just going to add one quick thing to that, just helpful, hopefully for the audience too, since we don't want to be too US centric here, is that like to Colin's point, like I think money bail is already, it's like a quasi risk assessment tool, right? For most jurisdictions, right? Whether it's a county or a city that's court system in the criminal legal system, they have a bail schedule, right? And they've quantified bail based on the charge from what they consider least serious to high, the most, right? So somebody that gets charged with, like recently with the uprising protests, we saw people be giving terrorism charges, right? They were being given $1 million bail, whereas somebody who might have been picked up for misdemeanor shoplifting might have been given $100 bail, right? So like the system has already, the money bail system is like this incredibly problematic, quasi risk assessment tool of its own, because there's been these judgments of the bail amount will track with some concept of the seriousness and the risk. But with like zero accountability and obviously like non-scientific and incredibly problematic in all the ways.
Oh, and sorry, just to add one thing, just because someone asked about this connection with wrongful convictions. And I think that this is an example of, often the ways that algorithms get deployed in our system are just like for what a lot of what Pilar talked about is for monitoring, is for supervision, is for predictions for someone who's been accused of a crime. You could really imagine, predictive systems being generated off of wrongful conviction information, right? Like you could very easily train a machine learning algorithm to learn the details of cases that have been exposed as resulting in wrongful convictions, and then run that through court data and find what other likely cases come out. In fact, this is a lot of how wrongful conviction stuff has been exposed in the United States, not in an algorithmic way, but in just a personal judgment way. Like if we look at DNA evidence and things like that, it's finding patterns in cases and seeing what might be exposed. So I think that there are opportunities. We just need to expand our thinking.
But what about this argument that was touted, I think, at the initial stages when a lot of these systems were being marketed, that they remove some of the powers away from the judiciary to make decision making much more colorblind or neutral? Is that something that we can say has been disproven by things like research that's been done in Kentucky, as well as the experience of systems like PSA, I think, that's been fixed on a number of occasions to make them less biased, but there seems to have been I don't know, kind of some reluctance to find that kind of debiasing has worked.
Yeah, I mean, I totally agree. I mean, I think that I think that's where we're at in a lot of the conversations right across the country in the US, right, is pushing that, right? That there's, as more studies come out, similar to the one that Mick Stevenson did in Kentucky, and as more organizers are quantifying, and right, that judges, that the tools, that lack of bias doesn't actually translate, right, in the actual day-to-day use of the tool, and particularly when looking at adherence to the recommendations, right? If we agree that the recommendations themselves are flawed and scored on racist data, and then even off of that, they can't follow it, right? Like that. But I think that people are still moving it forward. Like, I mean, the number of state legislatures in the US, right, who mostly meet in the spring, who are set up, right, to in January, February, meet and talk about how great pretrial risk assessment tools are going to be for taking out the bias. Like there's, that's still proceeding, right? We haven't won that yet, but I think it is starting to be more of the dialogue. And hopefully there'll be more and more research that can assist in making that point.
Yeah, if I can just add to that, I think it's been very clearly disproven that the non-objectivity of these decisions has been kind of very clearly disproven. I think everyone here spoke about the potential for discrimination in these risk assessments, these predictions. I mean, it all stems from the data. There's another question on kind of what if you removed ethnicity or race from the data, and that fits into this, because the problem is that the information that is being used, criminal justice data, it reflects the structural inequalities of the societies we live in, whether that's certain groups, ethnicities, areas, people being over-policed. Criminal justice data only represents, it's only an accurate record of policing rather than an accurate record of crime. And as that information finds its way into those systems, or that information is reflected in criminal justice data, it finds its way into the systems. Therefore, these systems cannot be considered to be objective. They can only be considered to be a kind of an objective outcome of the inequalities and the inequalities of the society that we live in. These systems will accurately predict law enforcement action, but they won't accurately predict kind of people's likelihood of reoffending. And the problem is that proxy, the way that even if you take out race or ethnicity, other information such as people's home addresses, or their financial situation, that information can itself be a proxy for race or ethnicity. And there are so many different forms of information that can be a proxy for race or ethnicity. For example, in many European countries, there's very pronounced ethnic, effectively residential segregation, making it highly probable that predictive systems will inadvertently establish that correlation between someone's area and effectively their ethnic origin, and therefore their risk. For example, in Europe, Roma are vulnerable to that form of proxy discrimination, given that in many EU member states, Roma live in often segregated areas, inhabited exclusively or mostly by other Roma. Or for example, in Sweden, there are also high levels of segregation for kind of migrants from non-European countries. So that's a kind of clear example of how other information, even if you remove race or ethnicity from these systems, how you will still be getting discriminatory or biased results. And they're just, people have done very complicated and complex statistical analysis, which is beyond me, but which from the experts, it's almost impossible to de-bias a data set. What you're effectively doing is removing the information that is there. When you de-bias a data set, what you'll get is something that is completely meaningless. If you remove the bias in criminal justice data, you won't find there's much left. So that's the kind of the simple response to questions about removing race or ethnicity. You can't remove it from this conversation or this issue, and therefore I think the more simpler solution is talking about removing these systems from the criminal justice system.
Thanks very much. So we have to really press ahead with these questions. I'm afraid we haven't much time, so I've kind of identified two really interesting questions. One is, I think, primarily for Griff, and the other, I think, is primarily for Colin. The one for Griff, I think, is we have a very interesting question that is asking, why the presumption of innocence is seen as so important and fundamental. I think we can kind of answer that. Answer that question, but I think perhaps the real question is, in what ways do you think these kinds of systems have an impact on the right to be presumed innocent, especially when we're talking about these kinds of pre-trial risk assessment tools, both in the pre-trial detention context as well as the kind of systems that we see like in the Hart model in Durham?
Well, I mean, the right to be presumed innocent is a basic human right, and it obviously just means that people need to be treated as innocent until they've been convicted of a crime following a criminal process. And the fact that these tools are used to influence that criminal process completely undermines the presumption of innocence, because what they do is they designate people as criminals, or effectively future criminals, people who are likely to commit crime in the future, to reoffend in some way. But before they're being designated as criminal, before they've actually done the action, before they've actually carried out any criminal or supposed criminal action that they're being profiled for. And they're being profiled as a criminal based on their past actions. which obviously fundamentally undermines that presumption that you should be treated as innocent until it has been proven by objective evidence otherwise. There's no evidence that these people have carried out these unlawful actions. They're being profiled on, all the information that we've considered, from exam results to area codes to, to whether their family or they have accessed benefits. This is fundamentally wrong to be profiling people based on that information. And then as a result of these profiles, they are subject to significant criminal justice consequences, being held in pretrial detention rather than being released, being sentenced to a custodial decision rather than released with a community order or a suspended sentence, or continuing to be held in prison rather than released as a result of a profile. So I think these systems and their results, they fundamentally undermine that presumption of innocence.
Thanks very much, Griff. And the other question I had, which is for Colin, Colin, you've actually answered this question in the chat, but I think it's a particularly interesting issue and something that's worth discussing in the webinar itself, which is around judicial responses to these risk assessment systems. Obviously, Pilar has talked a bit more about the kind of activist responses to the controversies around systems like Compass, like PSA. But I understand that this has been subject to judicial challenge in the US. So please.
Sure. So I mean, one of the challenges is that a lot of the challenges to these tools haven't really gone far. I think it's something, there's a line that, for people who can't do math and are afraid of blood, they become lawyers instead of doctors or computer scientists or something. And I think, the math part scares lawyers, it scares judges. And I think that there's a real reticence to even kind of approach or start to unpack these tools. In fact, like the leading case that we have in the United States that I referenced in the chat is State v. Loomis. And this is a case coming out of the Wisconsin Supreme Court, and it was someone who was sentenced in Wisconsin, and as part of sentencing, the Wisconsin courts used the Compass risk assessment tool. And this risk assessment tool, this person challenged the use of the tool, and it went up to the Supreme Court and of the state, and it's kind of like a typical thing for how we see cases go in the U.S. They basically just punted the question. The challenge here, as far as I remember the case correctly, is was a due process challenge. It was a due process challenge, and there was an equal protection challenge. I don't need to go into all the lawyerly details here, but the gist of it was that the person was arguing that the risk assessment discriminated against him on the basis of gender because it considered men and women differently, and then also that because he couldn't challenge the tool because there was no way to challenge how it was built, that violated his right to a fair legal process. And the court really just punted it, and they basically said that the gender difference was legitimate because men and women commit crimes in different ways, so they weren't going to look at that. And then the due process thing didn't matter because the risk assessment was one of many things that the judge relied on, and it wasn't the exclusive thing. In the pretrial context, we're not getting a whole lot of challenges, basically just because, in America, like there's no rule of law for the pretrial process for most of the country. These hearings are not meaningful hearings. In many places, you don't even have a lawyer at this hearing, right? Like there's some places you don't even have a lawyer. There might not even be a prosecutor. There might not even be a judge in the room. Like the judge is a magistrate who doesn't need a law degree, doesn't need a college degree. It's just, a local political appointment. And they kind of make a decision, as Pilar said, based on looking at a bail schedule. And then in some states, you don't have a right to appeal this decision. In other cases, even if you have a right to appeal, it is under the flimsiest standard of review possible, such that basically these decisions never get overturned. So in a lot of ways, we're not seeing challenges to it because the law doesn't afford and allow for these challenges, or in other ways, courts are kind of dodging the sort of central issues that should be considered.
Pilar, would you like to share any thoughts on that as well?
No, I mean, I just would echo. I mean, I think, you know, and the important piece I think that Colin raised, and this, you know, pivots back to sort of where some of the organizing has met challenges, is how there is no, you know, there is not a central, there's not a process for regulating the pretrial process, right? And it's so different in every single place. So even in a state, right, like in many of our very large states, like I'll use the state of California where I live, there's 58 counties, 50 of them use risk assessment tools. They're all very different, right? The systems are widely variant. There's no, right, I mean, there's been a recent thing in California where there was an attempt to get rid of bail and centralize the use of a risk assessment tool. It was voted down by the electorate for a mixture of good and bad reasons. It was both opposed by, you know, activist groups like the ACLU and many community-based groups, as well as the bail bond industry. But I think it's so, yeah, we don't have that sort of hook of a way to counter some of this legally, just because of how variant it is, right? And the need for folks to start looking at how even in a, you know, you could live 10 miles away and because of a county line have completely different ways of being dealt with pretrial, have different algorithms, have a different system versus public defenders or magistrates, have different, you know, ability to contest.
Thanks very much for that. Just as a final question, just on the Loomis point, for both or either of you, is kind of one of the interesting things from the Loomis decision, if pardon me if I'm making this up, but one of the kind of procedural safeguards that was being discussed in that was the idea of kind of notifying judges or decision makers about the limitations of these risk assessment tools. So in the Loomis case, I think judges got an alert or something saying, you know, Compass has been criticized by, you know, activists as being not very fair. So, you know, whatever, do what you want kind of thing. So what do you kind of like make of that as a potential safeguard when it comes to judicial decision making, and a potential safeguard against this kind of autopilot syndrome?
Thank you for bringing that up, Bruno. I totally forgot. I mean, that's like the funniest part of that decision, and like the best. I'm glad you brought it up. I didn't mean to omit it. I mean, I can't see that as being meaningful in any significant way. Like, here, we're using, here's this tool that tells you whether to put someone in jail or not. By the way, might not be trustworthy. That I don't see that as really a safeguard in any way. I mean, and we see this in different ways that these things get implemented, that it's just a bad way to cover your bases. I don't think that really, you know, if anything, you're like introducing a reform and undermining it at the same time. You know, I can't see how it would be helpful. Again, one of the problems with these tools is that they just give a judge a conclusion, and the judge can either accept that conclusion that the tool has or substitute it with their own. It's not not like the judge is going through a structured decision-making process and it's providing some information that can be really helpful for this part. It's really an accept or reject process. So I don't see how that's helpful. One person brought up in the questions asking, like, you know, which is better, the risk assessments or the judges? And, you know, the truth is that I think that's kind of another false binary, because the judges are never being taken out of this process anyway, right? They're always here. They're all, you know, ultimately they're able to override these tools and it goes to them. When it comes to the question of prediction itself, just prediction, I would say that the literature seems to say that on the whole, an actuarial tool is going to have moderately better ability to predict than judges in the mine run of cases. But a lot of the issues here, you know, stem from a limit on both judges and these tools' ability to predict, even if these tools are still just a little bit better than judges are as a whole.
And I know we're about time, but just to add, I mean, I do think that this issue of like how in the US, you know, the just lack of any real ability to have rules or oversight or community input in the pretrial process is so critical. Because like we could talk about the Loomis decision, or you could just talk about, there's a huge range of legal decisions and orders around bail, for instance, right? In many jurisdictions that tell judges you can only set bail if you do it at an affordable level for the person, right? In jurisdiction after jurisdiction, judges just go, well, looking the other way, I've decided that affordability is $80,000 for this person, even if that person could afford $1.15 is like all they have in their pocket, right? So I just don't think we like the incredible amount of discretion and the lack of any, you know, system for oversight by, you know, in the pretrial phase by the judicial arm is to Colin's point, like it's not going to go away, and it's actually like we've sort of kidded ourselves over and over that there's wins on, you know, various litigation in which judges just ignore exactly what they were advised they had to conform to.
Thank you very much for those remarks, and I would like to go on for another half hour or so, but I can't, particularly because I'm aware that it's like, you know, 7:30 in the evening in Bucharest, and I don't want to keep them away from their dinner or something like that. Thank you very much to all of our panelists, to Colin, and thank you also, Pilar, for joining us that early in the morning from California, and Griff, of course, once again, very fantastic contributions on this very interesting yet very mind-boggling topic. So thank you very much. And if this were a real kind of panel discussion, I would be asking everybody to give a round of applause to the panelists today. Moving ahead, there will not be a monthly webinar next month, given that it's December and it's Christmas and everything like that. But don't be concerned about that. We will be resuming the series of webinars in the new year. And also, just in case you hadn't had enough of webinars already, Fair Trials does have an action-packed program of webinars coming up in the next few months. And in December, if I can just kind of advertise at this point, we've got a brilliant two-day event coming up on racial discrimination with a specific focus on the rights of Roma defendants. So if that's something that you are interested in, wherever you're joining us from, that's definitely one to attend. But once again, thank you very much to all of our panelists, and a very good evening to you all. And this will be, of course, uploaded. The record will be uploaded, so that it can be enjoyed by you at any stage in the future. Brilliant. Right, bye.